judiciary and the rule of law. May I now request Mr. A K Ganguly, Senior Advocate, Supreme Court, Mr. Raju Ramachandran, Senior Advocate and former Additional Solicitor General of India, Mr. Soli Sorabji to chair the session. Mr. Prashant Kumar and Mr. V B Acharya, the former Advocate General Karnataka. May I request him to come to the dais. May I request Soli Sorabji to chair this session on independence of judiciary and rule of law. Thank you, sir.
Sorry for being late, but the rule of law is not observed by the traffic in Delhi. You know, rule of law is invoked so frequently and promiscuously at various seminars, workshops, lectures, that the constitutional historian Ivor Jennings got fed up and called it an unruly horse. But rule of law is not an unruly horse. It denotes commitment to certain principles and certain values. Now, one essential principle of the rule of law is that no action prejudicial or adverse to a person can be taken without the backing of law, without the authority of law. For example, the Commissioner of Police cannot say, oh, I think this meeting is going to be rowdy, so I'll prohibit it. Where's the law? One cannot even say, I'll ban a play on the basis of an administrative circular or a departmental order which lacks the authority of law. So this is a very important principle. Actually, this was laid down way back in 1931 by Lord Atkin. Lord Atkin, you only remember him for his dissent in Joseph Anderson. But he laid down the principle that no subject, of course it came from Nigeria, so no subject can be deprived of his liberty or property without the backing of law. That was in 1931. And actually, John Adams made a statement. He said, he used the historic phrase, a government of laws and not of men. He was not indulging in rhetorical flourish. He was emphasizing that law containing rules of general application and not individual whimsicality should govern the conduct and progress of men. Now, actually, friends, as you know, rule of law runs like a golden thread in our Constitution. Article 14, no discrimination under law. Article 19, which provides for restrictions on fundamental rights. First requirement is the restriction, apart from being reasonable, must be imposed by law. Article 21, no one can be deprived of life or liberty except by procedure prescribed by law. 25, religious freedom. So any restriction, anything our Constitution recognizes, it should be by law. And not, as I said, on the basis of departmental circular or something which doesn't have the sanctity of law. The other important principle, if I may call the basic tenet of the rule of law, is taken from that poet, John Fuller. Be you ever so high, the law is above you. That's an extremely important principle because that brings in the idea of equality. So you may be the Prime Minister, you may be the President, you may be the Shankardass, you may be the Imam, you may be the Archbishop of Canterbury. You are all subject to law, irrespective of your status. And that, according to our Supreme Court, the doctrine of equality before the law is a necessary corollary to the rule of law. I'll tell you one thing about no one can get away. I was in Oxford. I had a little trouble with my leg, so I used to go by taxis. So the Pakistani taxi cab driver, so we became friends. He became very friendly with me because I said, "What's your name?" He said, "मेरा नाम जहांगीर है." अरे मेरा बेटा का नाम भी जहांगीर है. चाहे तो आप चार्ज नहीं करेगा आपको, ऐसा हो सकता है. But I won't charge you anything. But amongst other things he talked about, मंगा है, क्या है? What's talking about? साहब एक चीज है. ये ड्यूक का लड़का भी, the son of a duke or anyone, if he breaks the light or breaks any traffic offense, इसको पकड़ेगा. So taxi driver, Pakistani cabby driver was impressed by this principle of the rule of law, that however high he may be, he will be subject to the same law and same penalties. Now one thing I want to say, the other panelists will discuss this. Please make a distinction between rule of law and rule by law. Law is essential, but that's not sufficient. The law must have a certain core component, and the core component of the law is respect for respect for acts of violence and cruelty and discrimination against the Jews and against others, was thought to be justified by pointing to the existence of a law. So existence of a law by itself is not sufficient. That doesn't mean there's rule of law. Rule by law is different from rule of law, and I'm sure the panelists will develop this thought, and it's a very important thought, because Justice Stephen Sedley of the UK court, and I think I would quote what he said. He said the core component is respect for the basic human rights of the people and for human dignity. And in the words of Lord Justice Stephen Sedley of the Court of Appeal in UK, the irreducible content of the rule of law is a safety net of human rights protected by an independent legal system, and I'd like to add, protected by an independent judiciary. Because without an independent judiciary, human rights become just slogans. They become just parchment promises. So this is an important part. And one thing I would like to tell you, friends, because I get very irritated when they say it's a Western concept. There's nothing Western or Eastern or Northern or Southern about the rule of law. And I end by quoting what our great Judge Vivian Bose said, that rule of law is the heritage of all mankind, because its underlying rationale is belief in the human rights and human dignity of all individuals everywhere in the world. Well, I just thought I'd give up my few thoughts, and then we will request our panelists to start. And will you start, Ganguri? Yeah. And first person. No, yes. No, that's all right. A K Ganguly requires no introduction, senior advocate, and a very prominent member of the United Lawyers Association. He'll speak on the topic. And you go next.
Good afternoon, everyone. Respected Mr. Saurabhji and the rest of the panelists on the dais. Mr. Anil Divan, my dear friend Shankardass, my dear colleagues, members of the bar. It's indeed my privilege to get an opportunity to speak to you on a subject of this great magnitude. There's a lot that could be said on this subject, but I'm happy that Mr. Saurabhji has given you a short, brief introduction, but it says it all. On the component of what is rule of law, and the distinction which Mr. Saurabhji made, that there should be a distinction between rule of law and the rule by law. The closest example that I would like to give to you is the celebrated decision of the Supreme Court in Maneka Gandhi. They ruled in the context of individual rights under Article 21 that not only you should have a law, but the law must be just, fair, and reasonable. And this test was applied in all subsequent decisions of the court. So if you recall, a challenge to the Section 302 of the Indian Penal Code, which was upheld way back in the 60s by a constitution bench of 5 judges of the Supreme Court, they at that time had tested the validity of the law only with reference to Article 21. And as you know, the language of Article 21, all that you need to do it is, you can take somebody's life by an established procedure under a law. And all that they required to do at that time was to test the validity of 302. Do you have an established procedure of law by which a life could be extinguished? Of course, on account of his offense. And it was found the answer was yes. And therefore, the section was upheld. Many years later, I got an opportunity to question the very same question again before the court in a different context. A very young boy, you know, the very famous case, it was Sunil Batra. He was convicted of a murder, manslaughter, and sentenced to death by the trial court, confirmed by the High Court, and Supreme Court reconfirmed it. But while passing the order of confirmation of his sentence, the court considered an argument made by Mr. Chitle at that time. They look at the conduct of this boy. After his conviction, he had been suffering the jail terms. And he had actually come up with the real service to the inmates of the jail, so much so that he was nicknamed as the Nightingale of Tihar. So that was his performance. He was the only son of his father, well educated. He was doing his engineering in Jabalpur. And so there was a strong plea made that there are mitigating circumstances which should weigh in the mind of the court, that you should reduce his sentence from death to life. Now this case went further, and the question that I raised was that, well, you have declared Section 302 valid, but you have tested it only with reference to Article 21. But now that you are required to test it again, and since it's a question of life and death, you should reconsider the question again. The matter went to a 5-judge bench, as you know, by a majority of 4-1. Justice Bhagwati was the dissenting judge. He said that this section is bad because it lacks guidelines under what circumstances the court could award life sentence or a death sentence. Justice Chandrachud, who led the majority in that bench, he held that it was possible for the court to read down that provision and import into the provision certain guidelines, subject to which death sentence could be granted. That's how the rarest of rare cases, etc., have been, principles were initiated. So that's the example to give you that not only the rule of law, what kind of law that you should have to fulfill the mandate of rule of law. Now, as you know, our constitutional system, we make a distinction between the executive power, the legislative power, and the judicial power. But it is said quite often that is there truly a separation of power, or is it a case of a separation of functions? Now, if you go by judicial theories, like if you go by Montesquieu's doctrine of separation of power, etc., you may not find that the Constitution makes a clear distinction of that kind. Because you find that the legislature, for example, Parliament and the state legislature, they have a power of adjudication when they try cases of a person who is violating certain norms, like 10th schedule, changing of political party, going against the mandate of a party, etc., and they have a disqualification. For example, it's an adjudication. The so-called notice is given to him, etc. Then, a removal of a judge, that's also kind of an adjudication. The Parliament, both houses, they decide whether a judge should be removed on the proved misconduct, etc., or not. So there are a number of functions which you find that the legislature exercises which are purely judicial in action. In good old days, there used to be a tribunal attached to the Parliament for deciding election disputes. Many years later, it was shifted the power to the High Courts. And High Courts are even today called the tribunals because of the old traditions that you get. So you have if you look at it, there are overlaps. Like the courts, for example, they make law, like you have Supreme Court rules. Court has framed it, of course, with the approval of the president. But this rule-making power is a pure legislative act. This is not a pure judicial function. So likewise, you'll find there are a lot of overlaps of power. So there is no, in the strict sense of Montesquieu doctrine, or separation of power doesn't exist. But there is undoubtedly a very clear demarcation of the functions of the institutions. The powers and functions of the court is to act as, to adjudicate upon disputes and to protect the rights of the people, which is again constitutionally entrusted on the court. the powers of the legislature is to legislate, executive is to follow the mandate of the law, whether it is coming from the legislature, implement them, or from the judiciary. So the functional efficacy is being maintained, and there is a strict functional discipline under the constitutional system, so much so that one would not allow to encroach into the area or the field which is demarcated and given to the other. That is how in a constitutional government, particularly in a democracy where you have three important pillars, you have the executive, the legislature, and the judiciary. They must have respect for each other. They should respect for each other's territory of exclusive power, and then carry forward the goal of the Constitution. That's the mandate of the Constitution. Now, why do you need independence of a judiciary? That's a very important topic. You may have a rule of law. And as Fali said, as long as you ensure that the rules are in conformity with the constitutional mandate, is that not enough? Then why do you need an independent judiciary? And what is the concept of independence of judiciary? So as I told you that there is a clear demarcation in the functions. In order that the judiciary is able to discharge its constitutional functions of acting as the protector of the rights of the citizens, which includes citizens' fundamental rights and also human rights. Now, the human rights are part of the fundamental rights by reason of several decisions of the court. How would the court discharge this function unless the courts are insulated from any outside influence, that is the executive influencing them or the legislature influencing them? Now, how is that independence secured in terms of our Constitution? The Constitution, the framers of our Constitution had a huge debate as to what kind of system that we should have, a judicial system in this country. We had the available model like what you have in USA, where all appointments go through the process of a Senate. That's a political intervention of a political group of people who are the legislatures. They decide who should be finally appointed, although through the aid of the president. But it goes through the Senate process. So there's a political process of appointment of judges of the superior courts. You have the other system, say, which is very well known to us, that is the system in the United Kingdom, where the appointments is made by the Crown, which is nothing but the executive government. So on the one hand, you have a legislative intervention where the judiciary is appointed, and in the other case, you have executive who decide. Now, these two options were available to our constitutional makers. The question was, which of the two should be accepted? There was a big debate. There were propagators of both these views. But eventually what the constitutional makers adopted for our Constitution was something midway, neither the American way nor the United Kingdom or the English method. So what they suggested was a unique method, and which is what you will find under the Constitution, Article 124 and 217 of the Constitution, for appointment of judges of the Supreme Court and appointment of judges of the High Court. The method that they selected was that none of them, neither the executive nor the judiciary, should have a veto power. That's the essence of the provision. Both should have an equal say in the matter of appointment by a process of consultation. The Constitution provides, I'm not talking about how it has been interpreted by the Supreme Court later years, but the text, going by the text of the Constitution, the President of India, in consultation with the Chief Justice of India, where the appointment is not of the Chief Justice of India's post, shall